Hello everyone, welcome to Management 413 Employment Law here at the UAB Collat School of Business. In this video we will be covering the termination of individual employees' employment using Chapter 18 of our textbook. Here's the chapter outline. We're going to be looking at the meaning of the word termination. What does constructive discharge mean? We're going to be revisiting the concept of employment at will and how exceptions have been created. We're going to be looking at the grounds for termination. We'll be looking at a special category of employment where just cause is required to terminate someone's employment. And then finally, we'll be looking at handling terminations. As HR professionals, I think we all need to remember that the loss of a job can be a very, very life-altering event, and we as employers should be taking it seriously, not only for the legal risks that arise, but also for the personal effect that terminations might have. The legal standards governing terminations differ depending upon what industry you are in. Most of this chapter deals with the private sector as opposed to the public sector. In the public sector, there is a concept of just cause and due process, which makes it more difficult to terminate an employee in that sector. Sometimes disputes can arise over whether somebody quit, whether an employee quit, or was that employee fired. The law has developed the concept of constructive discharge when someone technically quits but can perhaps successfully argue that conditions were created by the employer that really amounted to the employee being discharged. There is a simulation on this, Chapter 18, Question 2, an employee who said he was constructively discharged when he was put on a performance improvement plan and told that he would be terminated if there was even one more complaint about him while that plan was in effect. Look at this case in your textbook, Stempel versus Nicholson, if you want to see a pretty egregious example of how a physician at a hospital was constructively discharged. We've talked about the concept of employment at will, which would say that anyone can be fired at any time. That was clearly the case before the 1930s. Since the 1930s, however, more and more exceptions have been created, and we will be talking about those in this set of narrated slides. Protections that can chip away at the very pro-employer concept of employment at will might come from the Constitution, from various statutes passed by legislatures, and from the common law. Here is a chart that you can look at that would set forth where some of these exceptions might come and protect you if you have been discharged. Stop and pause and look at those. Sometimes there might be a contract that would guarantee you employment, maybe if you're a professional athlete or a very high level executive. Those are not very common. Perhaps more common might be an implied contract. If there were an implied contract, that would be an exception to the concept of employment at will. So when might there be an implied contract? Well, there would have to be a promise, presumably made orally, probably should have been repeated. It should have been made by someone who had authority to make it to the employee. If the employee didn't hear it, obviously the employee can't argue that he or she had an implied contract. Sometimes an implied contract can arise from an employee handbook that, for example, has a very long list of things that if you do them, you get discharged. And some employees might argue, well, as long as I do not do any of those things, I have a job. I have an implied contract. The way that most employers have gotten around that is to have some sort of disclaimer in the handbook that says that the handbook is not ever to be viewed as a contract of any kind. Occasionally, employers will make changes to the handbook for employees. The best practice is to give employees notice of that. And as I said, the best practice is to have some sort of a clear disclaimer in the manual, in the employment manual, that says that the manual does not amount to an implied contract. That will generally work, but here's an example of a situation that might apply to you. If you work for an organization where the employment handbook says that employees can be discharged at any time, but they will get the benefit of what's called progressive discipline. That is, that the first offense will usually not result in termination. That might be an exception to the disclaimer that says they can be discharged at any time. So you need to be careful in your employment manual to make it clear that in certain circumstances, the progressive discipline would not apply. Most employers will require that employees acknowledge receipt of the handbook and acknowledge in particular that there is a disclaimer of any implied contract. Some other contract-related claims that might be brought by an employee would be that the employer has a duty to deal with all employees in good faith and fairly. Look at this case on page 676 of the textbook, where an employee was discharged shortly after he brought in a big order that would have paid him a commission, but before that commission was in fact paid. Sometimes contract claims can arise when one employer causes an employee of another company to break the employee's relationship with the other company, or maybe a company will blacklist a former employee. In any event, if you are interfering with the rights, with the contract rights, the ability of one of your employees to enter into a contract, that might be a problem. Public policy. What is public policy? Public policy is the general sense of what a state or the federal government wants to see in life, perhaps not reduced to a specific law. And over the years, a number of public policy exceptions to the employment at will doctrine have been developed. Here are 4 kinds of public policy exceptions to the employment at will doctrine. One would be that you can't be terminated for refusing to commit an illegal act. You can't be terminated for exercising a legal right, for performing a public duty, or for whistleblowing. Let's look closely at whistleblowing. Most states have some sort of whistleblower protection law. The federal government does as well, particularly in laws that regulate industries that are very safety sensitive, such as aviation or nuclear power. In addition, a number of federal environmental laws like the Clean Water Act or the Clean Air Act would give whistleblower protections for employees who report environmental violations. Look at this healthcare industry whistleblowing case where a employee of an assisted living facility blew the whistle on her superiors falsifying training records. The federal government has a general law called the Whistleblower Protection Act that would prohibit an employer from discriminating against or retaliating against an employee who blew the whistle on a violation of law or who blew the whistle on gross mismanagement or gross waste of funds. Here's a whistleblower case under the Sarbanes-Oxley Act, which applies to the financial reporting by publicly traded companies. Even though it was an immaterially small amount of money, a woman at this public company, Lockheed Martin, blew the whistle on her superior for using funds to pay for the superior's sexual liaisons. Not a lot of money, but the superior should not have been using company money, and the employee who blew the whistle was protected under the whistleblower protections of Sarbanes-Oxley. The federal government has another law called the False Claims Act that is designed to encourage federal government employees or companies with federal government contracts to blow the whistle on false claims. And in order to incentivize people to do that, they will allow a very large recovery and they will allow it to be shared with the whistleblower. There are laws that are sometimes called civic duty laws that will give additional rights to someone in the workplace, for example, for serving on a jury or for serving in the military. We've already talked about USERRA in an earlier class, the law that protects military members and helps them get reinstated in their former jobs. Occasionally, employees will argue that what they do in their own time should not affect their jobs. That is not set forth in the law in most cases, but there are about 25 states that do have some sort of off-duty conduct law that protect an employee's ability to do what he or she wants to do off the job, but they're generally limited to the use of tobacco and other lawful products. There is always a danger in any employment action, as we have discussed in prior learning modules, that the action might have a discriminatory effect or might actually be disparate treatment, either one of which would be illegal. Here are the elements of a claim for disparate treatment in termination. Someone was terminated, but then a similarly situated person was not terminated. The difference between the two might give rise to a disparate treatment action. Courts differ on just how strict they will be in looking for a similarly situated person, but a good rule of thumb is to enforce termination policies in a consistent manner, regardless of whether or not someone is in a protected class. Look at the example on page 697 of your textbook where an African American cashier was terminated for discrepancies in her cash drawer, even though at least 16 other mostly white cashiers had not been terminated. That sounds like disparate treatment. There is yet another exception to employment at will, and that applies to all unionized employees. Generally, if a company has been unionized, there has to be just cause for someone to be terminated. In other words, there has to be good reason, and there has to be a process followed. The same concept, even if there is not a union, is in place at most government employers, including, for example, faculty members at UAB. In addition, public employees will get the benefit and an exception to the employment at will doctrine from some laws, such as the civil service laws, or from the United States Constitution directly. How might that work? Well, let's look first at the concept of tenure. Teachers and professors in public schools and universities often have tenure. It has to be earned. At UAB, for example, it takes anywhere from 6 to 10 years to get tenure. Once a faculty member is awarded tenure, however, the standard for dismissal becomes extremely high. For example, at UAB, a tenured faculty member can only be dismissed for cause, and the cause has to be a very serious failure to fulfill an obligation to UAB or gross professional misconduct. Public employees, whether they're faculty members or not, might rely on the Constitution for protection of their jobs. The Due Process Clause of the U.S. Constitution might give them a property interest in their jobs. Public university faculty members would have that protection, that the right of tenure is a property right that cannot be taken away by a public entity without due process of law, or they might have a liberty interest under the Due Process Clause. Due process means that their employment cannot be taken away without a hearing where there has been notice and an explanation of the evidence. Due process rights can also mean that the employees have First Amendment rights. However, employees at public universities and other public entities don't have unfettered right to say whatever they want and say that the First Amendment is going to protect them. The First Amendment will only protect them when they are speaking as a citizen on matters of public concern. If they try to speak out and say whatever they want in their capacity as an employee, that will not work. Here's an example from Alabama just in the last couple of years. An official of an Alabama community college testified in court that the woman shown here was not really doing her job. He was later fired. And he said, well, I should not have been fired. What I said in court should have been protected by the Due Process Clause of the Constitution because my employer, Central Alabama Community College, was a public entity. The community college argued that what he said was an internal matter, and the court disagreed and said, no, this was, by the time he was testifying, a very public matter, and so he should not have been fired. Terminations should be handled very carefully. Again, remember that these are people's lives we are talking about. Employers should really not jump to termination as the first thing that you would do. Are there any alternatives? Retraining, transferring, perhaps offering the option of resignation should always be thought through. In any event, if there is a resignation, the resignation should be documented and it should say that it was voluntary. Remember, if it's not written down, it may well turn out that it's as though it never happened. If there's going to be a drastic step such as a termination, it should be reviewed by at least one level up from the person making the decision. Perhaps employees should first be placed on administrative leave if some sort of investigation is necessary. Sometimes employers will offer severance when people leave, perhaps in order to avoid a legal battle with an employee whom they want to leave, and they will tell the employee, we will pay you a certain amount, but in exchange you have to waive your right to sue us. There are some very, very specific rules required if the person getting a severance arrangement like that is over 40, and you can take a look at these slides to see what is required under the Age Discrimination in Employment Act that we've talked about in some other contexts. If you're going to ask someone to waive their right to sue you after they've left the company for being discriminated against on the basis of age, you have to have a very clearly written document, and you have to give them the right to change their mind, and you have to give them the right to think about the offer in the first place. You can see what the time periods are here. That's it for this set of slides. In the second half of the last learning module, we'll be looking at Chapter 19, Downsizing and Post-Termination Issues.